And our next candidate is Judge Jennifer Bailey. Good morning, Judge. We'll let you get seated and settled. And you can begin your remarks when you are ready.
Good morning. I am Jennifer Bailey. I'm a District Associate Court Judge in Burlington, Iowa. It's located in Des Moines County as indicated, and I serve the 8th District. It's primarily a rural area sandwiched between the borders of Missouri and Illinois on the Mississippi. As I mentioned to at least one commissioner during my pre-interviews, one of my favorite things to do in my quasi-judicial role is speak to students. So I speak to special needs students, elementary, middle school. But my favorite class to speak to is Mr. Olson's 4th grade class at Sunnyside Elementary. That may be because my son is 9 and I speak their language. I bring this up because really much of what I speak to these kids about isn't about the judiciary at all. It's more a story about following their dreams, doing what fascinates and excites them, and turning that into a career. And although we speak about all manner of subjects, and they all get to ask me at least one question, there is one thing that I always tell them, that I am not special. That even though people call me judge or rise when I walk into a courtroom, the fact that in their mind a judge is a person of importance does not make me special. And I think it's really important that they internalize that, or none of them will think such a job is attainable. That any job that requires a certain level of expertise or positions that involve a certain level of esteem are not just meant for the elite, for the rich, for the connected, for the powerful, for the geniuses among us. They are meant for anyone who has put in the hard work and who are bold enough to chase their dreams, even in the face of looming failure. And in fashioning this narrative for my 3rd interview before this commission, I have concluded that it's what I want to say to all of you as well. That among a slate of candidates who appear truly exceptional, I am not special. I'm someone who has set goals, and I have met them. Someone who has translated what fascinates and excites them into a career. And someone who still has aspirations in furthering my service to this state. I would describe my service as practical, in the trenches, boots on the ground work in our juvenile and criminal justice systems. But for my first year out of law school, I've been a public servant for 15 years. As a prosecutor, I met with families of murder victims or those who themselves were victims of crimes. All of them had to rebuild their lives when the unspeakable happened. And I loved my work. I loved my work when the verdicts were guilty and the sentences were just. And I loved my work when the verdicts were not guilty. And when victims were left disappointed in our criminal justice system and sought answers that would never satisfy them. As a public defender, I loved my work. I held the state accountable in carrying their burden of proof. I held the police accountable in arguing for the suppression of evidence which was obtained illegally, unconstitutionally. I spoke to my clients to understand how to better defend them, but also to better understand the circumstances in which they found themselves, so that I could better build a chance to have lower recidivism rates. And as a judge, I am humbled by the power I possess over the lives of others. As I have pointed out previously, the vast majority of cases that I preside over are criminal or juvenile in nature. Those 2 areas of law also happen to account for roughly 2/3 of the cases that are reviewed by the Iowa Court of Appeals. Unique among candidates, I have played every role in juvenile and criminal matters as a lawyer or judge. I would also point out that only District Associate Court judges preside over juvenile matters, as we have exclusive jurisdiction, and that's over a quarter of the Court of Appeals docket. But I don't just want to discuss the meat and potatoes of my legal practice. I wanted to discuss what may give you pause when looking over my application. I am not a district court judge, and I spoke to some of you about the difference between district court and district associate court. I have not presided over multi-million-dollar lawsuits. The ceiling in small claims is just $8,000, though I would posit that for many litigants where I'm from, $8,000 might as well be $8 million. I have not presided over felonies beyond a Class D, though I have tried them as a prosecutor and public defender. What I have done is presided over a tremendous amount of Class D and misdemeanor cases, all of which involve the same rules of evidence and criminal procedure. I have sentenced defendants to lengthy incarcerations, though none to life in prison, but I can tell you that in each sentencing, whether for probation or prison or jail, the enormity of my job is never lost on me. My cases involve the lives of real defendants, real victims, and my want to serve the law and pursue justice is just as strong in my associate courtroom. My experience in civil work is remote in time and small in scale. But for my 1 year in private practice, where I handled dissolutions, probate matters, and general defense litigation, my civil experience is found in small claims, enforceable entry, and detainers. I will have much to learn if I'm appointed to the appellate bench. Though I would posit that no applicant is an expert in every area of the law, and perhaps what should be looked at is an applicant's work ethic and demonstrated abilities. And to that end, I offer the following. I'm a hard worker. I pursue excellence in everything I endeavor to take on. I set goals and work toward them, and many times exceed them. As I discussed before, I set a goal entering college to graduate with a 4.0, but for an A-, I met that goal, of which I'm proud of because it wasn't easy. I talked to my kids and they roll their eyes, but probably one of the grades I'm proudest of is music composition because I've never played an instrument in my life. And it was the most difficult class and I've never used it again, but I keep telling them, it doesn't matter. You have to put the work in. And so, because it was a challenge, not because it was easy. I wanted to graduate law school from a top 20 school in the top 20%, and going to the University of Iowa was able to do so. And I wanted to be a judge, and in doing so, knew I would have to gain a reputation for honesty and integrity. I would have to show a breadth of experience worthy of the bench, and show an ability to effectively argue the law. And I took the bench at the age of 36. As a judge, I want to be knowledgeable, fair, and efficient. In that vein, I have never taken longer than 60 days to rule on any matter. My retention rates in Des Moines County were 83%, and my first and only retention election, the highest among judges in my district that were up for retention. And my plebiscite results were overwhelmingly favorable, which shows the trust placed in me by the attorneys in my district. Finally, and I shall knock on wood, I have yet to be reversed by the Court of Appeals or the Iowa Supreme Court. In looking at the field of candidates, I would offer for your consideration that there is no one on a current court of review, whether it be the Court of Appeals or the Iowa Supreme Court, that hails from the 8th District. With the vacancies of Judge Miller and Judge Mullins, that is true for both courts of review. I would also note that I am the only applicant, but for one, who has applied in each of the last 3 vacancies. With regard to the 8th District, the 8th District is rural, as I indicated. If you didn't practice in the 8th District, although there's much drug addiction and issues with substance abuse across our fine state, you may not know that in District 8B, where I preside over criminal and juvenile cases, there are no long-term inpatient substance abuse beds for women or children or males. And so many times, parents, defendants are left to make a choice. Get the treatment that they need or see their kids. Get the treatment that they need or be able to be involved in the lives of their families or other services that have become a part of who they are in our community. If you didn't practice in the 8th District, you may not know that in many of our most rural counties, like Louisa County, there is no bus service, that many times the services and even the courthouse are so remote that they're prohibitively far away to walk to or even get to. And so when talking to litigants and when fashioning court dates and ordering services, we have to do things that are creative, like order the department to get bicycles or order other means of transportation. And so that is unique to our district. If you didn't practice in the 8th District, you may not know that certain pockets in the rural counties in the 8th have large Spanish-speaking populations, have large populations of the Burmese, and what that means insofar as making sure that they receive the services and access to courts that all Iowans deserve. In looking at the field of candidates, again, I offer that I'm the only candidate that has, in the last year, applied for all 3 vacancies, but for Mr. Miller. Though unlike Mr. Miller, I did not apply for the Iowa Supreme Court, and I note that only to demonstrate that my interest lies exclusively on the Court of Appeals. In closing, I'd point out the driving force behind my application to the Iowa Court of Appeals. It is my love of legal writing. Legal reasoning and analysis are an art form, and when analysis is compelling and impactful, litigants and attorneys develop a deeper understanding of legal concepts. I offer that my experience would enhance the court. I will continue to set goals and meet them. I will continue to be fascinated and excited with the cases assigned to me, whether within my current practice area or outside of it. And I will continue to be a faithful servant to our Constitution and the laws of our state. Thank you, and I'm happy to answer any questions.
Thank you. We'll start our questioning with Commissioner Spies.
Thank you. Good morning, Judge.
Good morning.
You know, having been a magistrate myself in Johnson County, I often thought that the roles of magistrate judges and district associate judges were really, really important, because sometimes that's the one and only place where people see the court in action. And could you tell me how you view the role of the court as an education function for both the litigants and the public?
Thank you. Well, in the district associate bench, as I indicated in my application, in Des Moines County where I serve, I also serve as a magistrate. So I do daily initial appearances, bench trials, etc. So truly, traffic citations, simple misdemeanor assaults, and then of course up to D felonies. There are a tremendous amount of litigants who represent themselves in small claims doing magistrate work and or simple misdemeanor cases. I take it certainly as a calling to make sure that everyone in my courtroom, whether they agree with the decision or not, understands what I said and why I made the decision. It's usually why I don't hard and fast rule till the very end, because I see that they tend to stop listening once they note if it's an adverse ruling. But it's very important to me that everyone feel like they have their day in court. I mean, if you come to district associate court on any given day, there's a tremendous amount of litigants, and so it certainly is that for jury service, for individuals who get a traffic citation, that they are informed of what their rights are, that they're informed of the judicial process, and that they feel like they were heard, and that the judge presiding over their case was knowledgeable and competent. So that is very important to me. And we're kind of the face of the judicial branch for most Iowans. I mean, I think that's certainly true. So,
Thanks.
you.
And my hat's off to you for being a public defender, too.
Well, thank you. I appreciate that.
Commissioner Roberts.
Thank you. Good morning, Judge.
Good morning.
So we talked last week, and when we talked a little bit about your appellate experience.
Yeah.
So when we talked, I think what I observed from your application is that it doesn't look like you've actually worked on any appeals. And all the other applicants today have worked on at least some appeals.
Sure.
So, I mean, given that, can you speak to what other, any other appellate experience you might have that qualifies you to be nominated today?
Sure. I think, as would be very common for any public defender or any assistant county attorney that works in the prosecutor's office, that we don't handle the appellate division. So I would hope that wouldn't rule me out, given the fact that it would really rule out a large pool of candidates. And in my brief stint in private practice, I didn't handle any appeals. I can tell you as a judge, I consider being appealed. I don't I make my rulings based upon that. I do what I think is right and in accordance with the law. But, insofar as some of my writing samples, of course, you will see the law that's cited, or like State v. Salwe that I cited. I particularly noted what appeared to be the general precedent that had been upheld in a very similar case in the Court of Appeals, and differentiated the particular facts of my case, and was found to not have abused my discretion in sentencing and put forth sufficient facts in my ruling and sentencing to substantiate the sentence that I levied. And so certainly I haven't argued in this courtroom, but the law and the precedent that is ever changing within our state is something that's always in the forefront of my mind. And as I said, I think I'll be able to figure it out. Thank you.
Commissioner Parrish?
Thank you. You still have to review briefs and
Yes.
prepared briefs also. My question is, I picked a lot of juries in 8A and 8B over the years,
Okay.
and so I'm kind of familiar with that area. My question for you, and you outlined the differences between what may take place in the 8th Judicial District. What tools do you think you've learned in your experience as a judge and the prosecutor and the defense lawyer there that can help the Court of Appeals understand and deal with some of the issues that you've seen on a regular basis?
Sure, I appreciate that. Well, I will say, I think that sometimes when we talk about, difficult, challenging professions like being an attorney or a judge and being in the depths of criminal and juvenile law, there can be burnout, there can be becoming a bit jaded. I feel that over the years, I've certainly become more empathetic to everyone that comes into my courtroom. And so, it's particularly in juvenile work, I have real opportunity to directly converse with mothers, fathers, children that have been charged or adjudicated of an offense. And so that opportunity gets to aid me in fashioning the services to help them be rehabilitated or reunify their families. And so we talk about real life things going on within our district, within their lives, and how to best serve them. And so when we talk about, the experience that I have in the 8th, obviously what I touched on before, substance abuse, mental health treatment facilities, what we see is our substance abuse providers are 5 or 6 months out. Now let's look at the reunification periods for most children being 6 to 12 months before the state may choose to ask the court to file a termination of parental rights petition. So what does that mean? If a parent isn't able to get into a mental health evaluation or get recommended mental health treatment or substance abuse treatment timely based upon the services available in our district, how does that affect what should be offered them or how we should review those timelines? So there are a lot of things that can be learned from simple conversations, and the people within my district, I have appreciated. I feel like I've been able to garner a lot of direct communication and understand their circumstances. And one thing I think I've said to several commissioners, and it's true, although not with the appellate experience that I can put down on my application, but when reviewing cases in the Court of Appeals, they won't just be names on a piece of paper. These are people that I look directly in the eye and have really meaningful conversations with. And so although I may not have ever met the litigants involved in these cases, I know that they are real, breathing individuals with families and histories and lives, and that will never be lost on me because it's all I've done for 15 years.
Thank you.
Commissioner Hartka?
Thank you, and good morning, Judge Bailey.
Good morning.
Can you give the commission an overall impression of your judicial philosophy?
Sure. I think best encapsulated by empathy and accountability. I think that can translate over about every area of the law. I want to hear the stories and backgrounds of the people that I serve, and I felt that way as an attorney. But I also believe that accountability is extremely important, and that many times it's the bedrock for change. And so if we can't acknowledge what is the problem, if we can't acknowledge how to make meaningful change, then I don't think that we'll have much success in a particular case. I also think just generally as a judicial philosophy, I hope that the attorneys in my courtroom know that they can always come to me. I want there to be attorneys and other judges that are new to have an opportunity to learn from my experience and me to learn from theirs. I think we're better together in that regard. And I've tried to certainly have a collegial atmosphere within my courtroom.
We have time for one more brief question. Commissioner O'Brien?
Thank you. I don't have any questions.
Commissioner Graber?
Thank you, Judge Bailey, for being here.
Good morning.
I can see that you're a person that you set a goal and you're going to accomplish it. So I have no doubt that whatever you set for a goal, you're going to achieve that. For this appointment particularly, what drives you to set that as a goal I've heard you talk about, your love of writing, but what else is it about this appointment?
Well, I want to keep challenging myself. I think that's really important for me to continue to challenge myself and push myself. And I think that it's great to feel really competent and confident in where you are in your current job. And I could do this job until the day I retire, which would be many years from now. I could, because it's challenging enough and it's interesting enough, and you get to make a real difference in people's lives. But I believe that I need to continue to push myself into things that make me feel uncomfortable. This makes me feel uncomfortable. Going to the Court of Appeals would make me feel uncomfortable because it would be such an honor, but also such a tremendous responsibility because of the effect that the Court of Appeals has in forming trial courts procedure, trial courts practices, and I think that I would be able to aid the current Court of Appeals insofar as being a fair and just judge reviewing cases and using my trial court experience. Also, I've just found myself, as I've gotten a bit older, just kind of craving those ruling days and sinking in my chair and just letting the time go by really quickly and writing an opinion. And I really, as you said, I enjoy writing. And so I feel like, certainly, as I've said to other commissioners, every job I've had, I've missed as I've left, and I would miss this one. But I'm excited about the possibility, and it pushes me to keep trying.
All right, thank you.
Our time is up.
Thank you.
Thank you for your application, and we look forward to deliberating it later
Thank
this
you.
afternoon.
Thank you.
Thank you all.